Welcome, everyone. My name is Sarah Ray from the Bloomfield Public Library. Thank you for joining us today for Don't Lose Your House, Protecting Assets from the Cost of Long-Term Care. And we're excited to have Attorney Jeff Rivard here. So I'm going to pass the mic over to you.
Thank you, Sarah. Thank you for everybody for attending on a very nice, pleasant afternoon. Some quick housekeeping before we start. As Sarah said, we're the vast majority of our time in the next hour is going to be in listen-only mode, which means I can't hear any of you. You're stuck listening to me. I always love questions. I try to address them when I can along the way, although I think you can appreciate it's always tricky in this type of a forum. There is a chat box, and Sarah's pointing out, depending on what sort of computer you have, it may be on the right of your screen, might be on the bottom of your screen, not sure. If you throw questions on there, I will try to address them if I can. The other thing I'll try to do is I'll try to allow a few questions at the end, as Sarah said, where she can unmute, we can ask questions that way. So, as Sarah said, my name is Jeff Rivard. I'm one of the attorneys from Zbiga, Daly, Pope, and Perry. Thank you, everybody, for joining us today. This is a very, very dense topic. There's no way I'll be able to tell you everything there is that one could possibly know about this topic. However, hopefully there's some kind of big important points that you can take away in the next hour, dealing with a super important topic, which is sort of trying to protect our home and other assets in the context of long-term care. So let's dive in. So the first question, sort of the teaser of the topic that we labeled this presentation, can I really lose my house? Well, the answer is yes, but like a lot of the topics we talk about as estate planners, we can kind of unpack this a little bit. So as we say in this slide, it is true. If you enter a nursing home and spend all your money on care, you may very well have to sell your home. Or to be fair, your family may have to sell your home, since a lot of the folks we deal with by the time they're in a nursing home, through no fault of their own, we're typically relying on another family member to help take care of affairs, okay? Now, do we always lose the home? Not necessarily. Let's come back to that. For starters, as we point out here on this slide, Connecticut has the dubious distinction of being the second most expensive state in the union when we talk about healthcare. Any guess as far as the front runner? Well, if you guessed Alaska, you'd be right. And that the main reason there is because everything's higher in Alaska. So of the other 49, we've somehow managed to be the front runner when it comes to cost, which I think is probably not something the state tourist board we probably don't want to brag about. So how expensive are nursing homes? How expensive? Well, they're pretty darn expensive. As we put on the slide here, the average monthly cost is about $15,000 a month. That's average. And what do we know about averages? Well, some are higher than that. Some may be lower than that. It's actually, there's a more precise figure than 15,000. It's the official average. I'll come back to that, but as a rule of thumb, you can think of that. And that comes up to $180,000 per year. That's a lot. That's a lot in the sense that a lot of families who I might say are pretty well off financially, when we shift to long-term care, we say, boy, we don't have nearly enough money. And as we say here, if you run out of money, Medicaid pays for your care. Now, what is Medicaid? Well, right off the bat, a lot of people are very blurry between Medicaid and another M word, Medicare. So a lot of people may say, well, if I get older and I need to go to nursing home, no problem, Medicare will pay. Well, that's not true. So first of all, Medicare is health insurance. Medicare is essentially the government's health insurance that's provided to folks when they reach a certain age. And health insurance basically means they'll pay for visits to doctors and pay for procedures, but they very much do not pay for long-term care. If somebody is getting care, but it reaches the stage where it's considered long-term care, Medicare basically it will immediately stop covering. And then Medicaid hopefully will kick in. Now, why did I say hopefully? Well, there's an important point we need to understand about Medicaid. Medicaid is not an entitlement program. We could contrast that to Social Security retirement. That's an entitlement program. If somebody's worked enough quarters, sometime during their working life, they put in enough time, a certain number of hours worked, the government has to send you a check. Medicaid does not have to give people checks for anything. Medicaid is a means-tested program. And what it is behind the means testing concept is a bunch of very, very picky and difficult rules and restrictions. There are a lot of hurdles that you have to jump over before Medicaid starts paying for somebody's care. Now, an important point here is, as we say in our first bullet point on this slide, it is a joint state and federal program. Essentially, the federal government hands a bunch of money to each state and will say to each state, you go ahead and set your specific eligibility rules for when you say somebody's qualified for Medicaid to help pay for care. But you need to make sure your rules are within sort of these guidelines. In other words, you set your maximum, but no more than this, and you set your minimum, but no more than that. But within those barriers, if you will, you go do whatever you want. And Connecticut just so happens to have the reputation of being one of the most difficult states where, if given the option, the state of Connecticut tends to kind of push the rules as far as they can. In fact, in our biased opinion as elder law attorneys, we think the state has gone beyond what the federal rule allows. There are times at which we've been involved in litigation where we've sued the state of Connecticut and we said, no, no, no. Federal law says you're only supposed to go this far. And therefore, when the state has set a rule up here, we say you've gone beyond. And a few times we have, in fact, beaten the state at that, if you will. So this last point, this is important to understand because a lot of people don't appreciate this. We think of Medicaid as synonymous with nursing homes. That's not always true. It is true that a lot of people in nursing homes in Connecticut, as much as 3/4 of people in nursing homes in Connecticut are being paid for by Medicaid. But it's also true that Medicaid pays for a lot of people who are getting home care. In fact, it may be true that as many people are getting Medicaid home care in Connecticut as they are in nursing homes. So don't lose sight of that fact that the Medicaid home care program may very much be on the horizon for you or your family. So when we talk about Medicaid eligibility, I don't exaggerate when I tell you I could sit here and talk to you all day about all the nuances about these, but if we sort of put it in 3 categories broadly, we have asset rules, we have income rules, and we have transfer rules. And if you think of it broadly speaking, these 3 rules, sometimes they sort of, how would I put it? Sometimes they intersect with each other in ways we can use to our advantage. Okay, so keep that in mind. We got a lot of asset rules, we have a lot of income rules, and we have a lot of transfer rules. So let's cut to the chase. Can't I just give away my house and my money? If I'm in the nursing home and I want them to pay, well, can I just give away my assets? The answer in red is absolutely not. Why is that? Well, that is because of the dreaded 5-year look-back period. Now, I'm sure a lot of us have heard that term. We may or may not know what it means. So essentially what the 5-year look-back period is, think of it this way. If somebody reaches the point where they're ready to apply for Medicaid, they're trying to get the state Medicaid program to pay for their nursing home care. At that point, you really have two tasks. The easy part certainly for an unmarried individual, the easy part is showing the state what do you still own in terms of how much you have in assets. The answer has to be very, very little. And if you have assets of any appreciable amount, well, it's going fast because we talked about the $15,000 a month. So that's the easy part. The harder part, and what turns the Medicaid application into quite an onerous task, even sort of in the beginning of the process, is the state is going to want to see a very thorough and comprehensive financial history of everything you've done over the previous 5 years. Every account you had open, everything you bought and sold. There's a lot of checks you need to give them a copy, a whole mountain of stuff. If you had a CD at a bank 4.5 years ago that you closed, well, that's a little smidgen of time within the 5 years, and you got to show it to them. And why do they want to see all that? They're going to basically look under every rock, and they're going to figure out if they think you gifted away assets. If they think you gave up assets and you didn't get fair market value in return. But it's 5 years, 5 years and no more. So think of that almost like the state's radar. They can scrutinize what you did up to 60 months ago, but not 61 months. If 5 years and a few weeks ago, you gave $1 million to your best friend from college, there's nothing they can do about that. Why? Earlier than the 5 years. But that same gift you made 4.5 years ago or yesterday is very much within their realm of scrutiny. That's why our slide about the fellow who says, can I just give away my house? The answer is no, because that's going to show up as a transfer during the 5 years. So here's an example of a fellow who makes the I guess in retrospect, unwise decision to try out the grandchildren skateboard. And he has fun for a few minutes until the wipeout. And unfortunately, given his bone situation, that was not good. So he breaks his hip. He has about $150,000 in a house. He ends up in a nursing home in his rehab. Now, this is an important point. A lot of people enter into long-term care from a prior hospitalization. In fact, I've heard statistics that most people in nursing homes start off with a hospitalization. This is an example where he's in the hospital for a few days, and they essentially say, well, George, we did the operation, but you're not strong enough yet to go home directly. So we're going to send you, we're going to make some calls, we're going to find a spot for you for at least a short-term stay in rehab. And when George starts in rehab, Medicare starts initially. But there's going to come a point at which Medicare will say, this is no longer short-term. This is now sort of turned into long-term. Or the reverse of that is to say, this is sort of reaching the point where this is not really a job for health insurance. This is really a job for long-term care insurance. And that's where Medicaid, and don't get confused by the term. I'm not talking about a long-term care insurance policy that somebody gets privately. I'm saying that's a job for Medicaid to start paying for long-term situations. So here, Georgia's $150,000, that's dissipated at the rate of about $15,000 a month. In rough terms, he runs out of money in month 10. And at that point, per the Medicaid rules, his house will have to be sold. Does George have to sell his house to get on Medicaid? Well, yes and no. Okay, this is a subtle point, but you can appreciate this. George or his family basically needs the state to be convinced that they are trying to sell the house. In other words, if they are making a bona fide effort If the family says to the state, look, here's a listing agreement with Sally the realtor, and we have a valuation, and we've got a sign on the lawn, house for sale. Now we're on that process. As long as the state is convinced they're trying to sell it, they immediately no longer consider it as a countable asset. When we talk about assets, a fundamental point there is not everything we own counts. Some assets count and some do not. And this is an example where no matter what the value of the house is, for purposes of making the decision, are we going to grant George's application? They would immediately say it's not available. What's the catch? The catch is eventually the house is going to sell. And certainly the last couple of years with a very hot real estate market, if this process drags on long enough, the state's going to say, are you really trying to sell the house? And they wouldn't necessarily buy the argument that they're really trying to sell if it takes too long. And here, as we point out, once the house sells, now that money in the bank will basically either prevent him from being eligible or kick him off if he was eligible. So that's why the house itself, it's sort of, we can position it so it doesn't count against us in the short term, but that's not really a long-term solution, if you will. Now, what about home care? This is very important. Some of the things that we're going to be talking about are of relevance to a married couple only. Other things, a single person. And one of the things to appreciate is when it comes to our home, our residence, it's exempt. It doesn't count as an asset as long as either the person that's applying for help with care is living there or a healthy spouse. And when I say healthy, what I mean is our spouse can have all sorts of problems. But as long as he or she doesn't need the kind of skilled care that's going to mean they also need Medicaid, then they're considered the healthy spouse. The technical terms, we call them the community spouse, meaning they're not institutionalized. And I always think it's sort of funny because if this is a home care situation, the two of them may literally be sitting on the couch together, watching TV in the evening. He's institutionalized, she's out in the community because he's the one we're trying to get the state to subsidize his home care, and for her, we're not. Okay, so as we say here, as long as somebody is at home, then it's exempt. Now, what's the catch here? All that it takes is one fall. And now all of a sudden, we don't have dad living at home anymore. We have dad in a facility, and now we're sweating it because we don't know if he can come home again. We were sort of banking on this home staying exempt, but it's not looking good. The doctors say, we don't think he's got enough strength to come home. And now they say, well, we thought we were going to be able to hold on to the house, and perhaps not. There's a catch. If you notice a phenomenon, almost everything I'm talking about here, there's a catch to all these things. The catch, as we put in red here, is it's true while the person who's needing care is alive, living in the home, it's an exempt asset, but the state certainly is allowed to apply a lien and to recoup what the state paid out in care after passing. In other words, mom gets home care, she dies. Now, after she's died, her executor sells the house. And that's where the state comes up and says, we're entitled to grab a big chunk of the sales proceeds. Why? We're allowed to be reimbursed for what we paid for mom before she passed. Hope that makes sense to everybody. I was going to say any questions. I don't think I see any questions thus far. So either we're dazzled and amazed or we're asleep. I don't know yet, but we'll see as time goes on. So scenario 2. My slide 1 was saying was single person. Here we have two people. So here again is George. This time, instead of a skateboard, we're on a bike. And he's the one off on the handlebars. Wife, she's the one driving, but nonetheless, I picture we're about to have a pitfall. So husband breaks his hip. She walks away. Same scenario as before. Same assets as before. They have the house and they have about 150,000. Now, the Medicaid rule says, even if George he starts in rehab, so he's hospitalized, then he's in rehab. Then at the end of the rehab, they say, he really can't return home. He's going to have to stay here long term. She's still in the home. So that's where she say the house is exempt. And since she's at home, they are not allowed to put a lien on it. It's only in that single person getting help scenario they could lien the property. She's allowed to keep some of the money. Some. We're going to come back to exactly what that means mathematically. But suffice it to say, with a married couple, between the two of them, they're not nearly as restrictive on the healthy spouse as they are for the institutionalized spouse. So that's right on in a nutshell is the difference between the single person and the married person. So when I said she keeps some of the money, what exactly should she keep? Well, the state, it's hard to stay away from some of the abbreviations. And one of the abbreviations for what this term is, it's called the CSPA, Community Spouse Protected Allowance. It's an amount of assets that they'll let the healthy spouse keep. Now, I've been in this business for a long time, and I've tried to come up with an easy way to describe this, and it still doesn't roll off the tongue easy. Essentially, they figure out a snapshot, a date and time, and they look at that date and time, and they say he or she is allowed to keep half of the amount of assets that essentially they had at that time. Now, this is in addition to a smaller amount that the ill spouse can keep. They say half of the rest, but he or she can't keep more than a maximum, and they can't force them to spend down below the lesser amount. Okay, there's another, I'm using terms, I should define them. What is spend down? Well, we refer to spend down as a situation where the state basically says you're allowed to keep this much, but you really have this much. So one way or another, you got to get rid of the difference. We refer to that as spending down your assets. So in other words, between 50,000 and 154,000, basically, if the healthy spouse had that amount of money times 2, then it's half, but otherwise it's between those two guardrails, if you will. I know that's a little confusing. I apologize, but I didn't make the rules. I already talked about the house. Let's jump to the second one. This is kind of interesting, the car. The healthy spouse can keep one car of unlimited value. In fact, if we have a single person, they still can keep a car. They can keep a car even if they can't drive anymore. And I think the state's logic here is between caregivers or other family members, it's foreseeable they're going to need wheels. They're going to need somebody to help take them to, say, doctor's appointments. So let them keep a car. And by the way, when I talk about this 154,000 versus 50, if we contrast that with the fact that a single person, the ill spouse, can't keep more than 1,600, this is a pretty big difference. 1,600 versus as much as 154,000. Well, this is one of those few times that I will concede the state's being logical. What they understand in the rules is they don't want essentially a second ill spouse because this person who's marginally healthy can't afford to stay out of the nursing home. So in other words, it's in their best interest to make sure that the healthy spouse has more money to stay independent for longer. That's why the rules are a little more tolerant with the healthy spouse than the ill spouse. So this car, what's kind of neat about this is, particularly in the case of the healthy spouse, it's a car of unlimited value. There's no restriction in the rules on the value of the car the healthy spouse is allowed to keep. Now, we don't do this that often, but an example that I always think it's cool when I share this, our firm handled a Medicaid application once when the healthy spouse had about $80,000 too much. In other words, under this CSPA, the state did the math and said, you got to get rid of 80,000. So what did she do? Well, we suggested she upgrades her car. She bought an $80,000 Lexus. She got to drive it around for about a 6 month or a year, had fun. The state was pretty annoyed about it. They didn't like this, but the fact is the rules had no prohibition on this. And after the husband's Medicaid was granted, well, then she sold the car because it's more car than she really needed. And the neat thing about this, from the perspective of if we have a healthy spouse as part of the situation, is when this says they have to spend down to a certain amount of money, that's a one-time requirement. There's literally one moment in time when they look at the assets and they say your assets are low enough. There's no requirement they stay that low. So in other words, when husband got on Medicaid, she sold the Lexus, her bank account surged $80,000 higher than the maximum, but at that point, her assets were none of the state's business. His assets remain the state's business, because if they're applying Medicaid, she needed to make sure his bank account stayed low enough at the end of every month here on in. But it was none of their business what her bank account was doing. That's why it was such a cool strategy. This is also important. Remember, I talked about asset rules and income rules. So what another thing, and again, I don't want to be sexist. We say the wife at home, it happens to be a wife in our example. It doesn't necessarily have to be a wife, although the demographics are such. Women do tend to live longer, so more often we're talking about the healthy wife instead of the healthy husband, but we certainly have both scenarios. But I wanted to make the point here that one of the fundamental income rules is when somebody's in a nursing home, as soon as they're applying for Medicaid and during the application process and after the application is granted, continually, all of the person's income has to get paid to the nursing home, except they're allowed to keep $75 a month for the luxuries. They call it the personal needs allowance. What are you allowed to spend it on? Well, I don't think there's a lot to spend it on. I've heard a lot of women will get their hair done in the nursing home. Beyond that, I'm not sure what the men spend the money on, but it's a little bit of luxuries, okay? But the rest of it, the nursing home gets all the income. But coming back to this slide, the healthy spouse never has to give a penny of their income to the nursing home. They keep all of it, even if they're still working, bringing in a high income. And so some of our planning strategies, we can try to maneuver things so that we can get a very high income flowing out to the healthy spouse outside the nursing home because we know they keep all of it. That's an important point. Now, this last bullet point is sort of a reverse point on that. Although the healthy spouse never has to give any of their income to the nursing home, sometimes the opposite is true. If the ill spouse's income is high and the healthy spouse's income is low, and or if they have high housing costs, the state will automatically sometimes apply a certain diversion. They may say, in this case, Mrs. Smith, instead of every penny of Mr. Smith's income going to the nursing home, we'll let you keep $500 a month. We'll let you keep $700 a month. Why? Because we want to keep you afloat. Because you're showing us your incomes are low, you have high mortgage costs, you have high property taxes, what have you. Okay. So transfers. One thing to understand right here is when we talk about transfers and we talk about penalties on certain kinds of transfers, there's absolutely no penalty on transfers between spouses. They can move assets back and forth as much as they want. It's simply not considered a gift for purposes of Medicaid. So here again, with basic estate plan, if we have a client where somebody's been diagnosed with dementia, but it's still pretty early, they're in pretty good shape. But we sort of say, you know, a couple of years from now, we're not confident he'll still be in good shape. Well, one of the basic things we recommend pretty early is start moving as many assets as we can over to the healthy person side of the ledger. Why? Because eventually we know we'll probably get to the point where we've got to make sure that his bank account is all the way down to 1,600. Now, sometimes this is easy to do, sometimes this is not easy to do. When is it easy to do? We have a savings account. We just write a check, move it to this account, no problem. Where it's hard to do are retirement accounts. If the ill spouse has a big IRA, one of the differences in states is not every state counts retirement accounts when they're trying to figure out assets for Medicaid. There are states that will say we're going to ignore the amount of your IRA. We're only going to look at other assets when we're trying to grab the calculator and figure out whether you have too much. Unfortunately, Connecticut doesn't care, and Connecticut says your IRA just counts just as much. Now, the built-in awkwardness there is, remember one of the things I said, the person who's trying to get help has to get down to 1,600, which means we can't get there with a $100,000 IRA. So one of the things we probably will need to do is liquidate the IRA. And of course, that means we have to pay income taxes. But that's one of the important things that would have to happen. And once that decision is made, whatever is left after taxes, well, sure, then that can be easily handed to the healthy spouse. Okay. Now, ignoring the fact that the state ignores intraspousal transfers, there are other transfers that are fully allowed. Here's two examples. The disabled child rule. You're allowed to distribute assets to a child, or actually technically any person who's disabled. Now, when I say disabled, we need to emphasize that what we mean is really disabled. Not, well, my brother's kind of flaky, he's never really worked, and we're not quite clear what's going on up there, but he's never been diagnosed. That wouldn't count. But if you say, you know, my sister had some mental health issues, she had to stop working 4 years ago, she's been collecting Social Security disability, that absolutely counts. And in that situation, we can transfer the home, cash, pretty much anything to that disabled family member. If somebody is disabled, sort of lowercase d, but they're not officially disabled, there is a way we can apply to try to get the state Medicaid authorities, that's Department of Social Services, we can apply to get them to look at medical evidence to basically say, are they convinced that Social Security would consider this person's disabled? In which case this counts. Now, one of the things that's tricky about this situation for us as estate planners is just because we can hand all of mom's assets to child A, because child A is disabled, doesn't ignore the fact that perhaps mom really, really wants A, B, C, and D to all inherit equally. Mom didn't want child A to end up with all the assets, even though the Medicaid rules say we get a free pass by deeding the house to A. And that's where we may work with the family as a whole to create some sort of a trust where we're within the Medicaid rules, but if there's money left, the people that inherit are consistent with what mom wanted. Okay. Second one, caregiver child, the caregiver child exception. So here again, just like I said, the state has a certain logic when it comes to allowing the healthy spouse to keep more assets. Well, the state also recognizes that nursing home care is expensive. And if there's times that a family member has basically put in the effort of being the caregiver for the parent for a certain amount of time, then as a reward, so to speak, to compensate that child, they will allow the house to be deeded to that child. Now, I said a certain amount of time, 2 years. The perfect factual situation, and I say that because our facts are not always perfect, but the perfect factual situation is daughter lives out of state. She leaves her job. She moves to Connecticut. She moves in with mom. She lives with mom for at least 2 years. She stops working and becomes mom's primary caregiver. Mom's doctors are willing to give a medical opinion, give a letter that says, as Mrs. Smith's physician, and based on the stroke that she had 2 years ago, but for daughter's efforts, she would have had to be institutionalized 2 years earlier. And the state recognizes that essentially that's 2 years worth of nursing home Medicaid care that the state did not have to pay. And they will allow this. Now, the medical opinion carries a lot of weight here. What the doctors say, what the doctors don't say. We don't have it on the slide here, but along with this caregiver child, there's another rule that is called OVC, other valuable consideration. Now, that's not limited to the home, that's limited to a variety of cash assets, but it's the same concept. There, if the state looks and they say, we're convinced that nephew, what he did for 2.5 years, basically saved us, saved the state 2.5 years worth of Medicaid. And therefore, we will allow 2.5 years worth of nursing home cost to be validly transferred to nephew as consideration for what they have done. So these are kind of tools in our toolbox that we may be able to use to help protect some assets. So we've got this spend down obligation, but we might say rather than spend $200,000 on something that the family doesn't want to spend it on, how about we put the cards on the table because we think the state would recognize that we're allowed to compensate this fair family member. So when we talk about spend down, what can we spend down on? Well, for starters, to point out the obvious, what can't we spend it on? We can't spend it on gifting. We can't go over to the next door neighbor and say, I'm supposed to spend down $200,000. You've always been a nice neighbor to me. Here you go. We cannot do that. It's got to be spent on essentially goods and services. Within being spent on goods and services, you have a lot of latitude. One option, now we don't have it on the slide, but one option that's always there is you can just keep paying the care facility at their private pay rate. And sometimes the family is more than happy to just do that. We may do the math. We're going to say, okay, mom is going to run out of money in 10 months. And the plan will just be to keep paying the nursing home at their private pay rate for 10 months. And round about the beginning of year 10 month, mom will be down to $1,600. And we'll plan on filing Medicaid application at that time. So that's always an option. As attorneys, we like to think a little more broadly and think creatively and think are there other things we can do? Well, certainly. So the first on the list, home improvements. If we already pointed out that the house is an exempt asset, and if it can be done sort of quickly, if $5,000 can be spent to repair the deck, and that improved deck is now going to enhance the value of the home, what did we just do? We increased the equity on an exempt asset. Now, I always sort of point out that it should be something that's got to be clear. You can't just give the state a note, okay, next year we'll plan on using this. It's got to be out of the account. So you find a contractor, you price out the work. I don't know if they need to do the work right away, but you need to pay them right away. You need to have a signed contract for the work that's going to be performed. Dental work. Medicaid is very stingy. When somebody's on Medicaid, they don't really pay for much in the way of dental work. Same with hearing aids. Hearing aids can get very expensive. If you can help mom's hearing by buying an expensive hearing aid before Medicaid, that might be smart. We have it as the third bullet point, but actually we should probably have this as the first bullet point, because this is one of the first things we ever start talking about: prepaid funerals. I don't know if you knew this, but funerals are expensive, very expensive. I do a lot of probate matters, and I routinely see bills as high as $15,000 or more. And certainly if we're talking about a person who has to spend down all the way to about $1,600, and every penny that $1,600 the state has dibs on after they pass, well, then there's literally no money left to pay for the funeral after passing. And that's why kids or someone else in the family might get stuck subsidizing the funeral. So this is smart to do. Connecticut, under the current rules, will let the either individual or both members of a married couple, each of them could put up to $10,000 in an irrevocable prepaid funeral. Now, as a consumer, I don't think it makes any sense to put $10,000 in if you don't think you're going to need $10,000. I meet with people that say, hey, I want a simple cremation. I don't want a service. Make it nice and simple. Okay. So maybe that only costs $1,500, $2,000. Well, then pay for it. This is one of the examples. Even if you don't need that much, that would be smart to do. And here, upgrading the car. My Lexus was kind of an atypical situation, but certainly if the wife says, the car is a bit old, I say, well, this is a perfect time to get yourself newer wheels. Because just like I said with the home improvements, the same thing is here. And the nice thing about cars is it's so easy to buy and sell. I mean, I could buy a new car today. I could sell a new car today. Very, very easy. Okay. So those are some thoughts. And certainly depending on the family situation, there's other things we might think about spending down. Now, everything we've sort of talked about has been from the scenario that we're sort of in hot water right now. We have the acute health need right now. We're kind of scrambling. In fact, where the most stressful times are the parent has been hospitalized. They go in for short-term rehab. The family thinks they've got time to work with, time to plan, and all of a sudden, the nursing home sends them the dreaded 24-hour notice. Medicare is going to cease covering, and in 24 hours, you need to tell us what's your plan. And if they haven't planned already, those are some of the most stressful meetings we ever have. Because knowing what I know about nursing homes are sort of, I think they take the traditional law of supply and demand, they turn it on their head. We all are trying to avoid needing a nursing home. But if we need a nursing home, there's not enough beds to go around. So they sort of are in high demand for something we're hoping we avoided. And the thing to understand is once somebody's in a nursing home, if you apply for Medicaid and you obey all the rules, the nursing home cannot kick you out. They have to obey the Medicaid rules. But if you take them home, if you take mom home and 2 days later you say this was a mistake, Mom's not strong enough to go up the stairs. We should have, if we call the nursing home, they might say, sorry, we don't have room, and they don't have to take you. So that's a very stressful situation. So coming back to this slide, we have a lot of clients that if we start planning early, and by planning early, ideally, we're talking about at least 5 years ahead of time because of the 5-year look back period. There are all sorts of strategies we can use to help protect the home, protect other assets, as long as we have 5 years to work with. Now, here's what's tricky. Everybody in the audience here, we're all going to live forever, and we're also going to stay healthy forever, right? Well, unfortunately, no. But as I look at the audience and myself included, I don't know who's going to run into problems. I don't know when they're going to run into problems. That's what's tricky about this. The best time to plan is long before the person is in ill health. So the point here on this slide is when we talk about Medicaid penalties, let's just define it briefly. What is a penalty? A Medicaid penalty is essentially a period of time where the state Medicaid authorities will say you're otherwise qualified for Medicaid. In other words, you've convinced us mom's bank account's low enough. You gave us all the mountain of paper over 5 years. We asked you a bunch of questions. You answered them all. We're ready to start paying the bills. But we have this problem. Your mother gifted away 3 months worth of care. Your mother gifted, in rough terms, about $52,000 worth over the last 5 years. So we're going to penalize her to the tune of 3 years. Where did I get that from? Where did I get that figure from? I got that figure because every July 1, the state publishes that as the official state average. Every July 1, they give you the official state average. And that's what they use mathematically to figure out a penalty. If they say dad gifted away $100,000, you take 100, you divide it by 14,524 on the calculator, you get an answer. That answer is the number of months of delay. And that's the point at which the state will say, it's not our problem for 4 months, 4.5 months. You and your family, you figure it out. After that, now we start paying. Okay, so if we want to act more than 5 years ahead of time, what can we do? Well, we have a lot of clients. Now, this is not for everybody. I don't want you to mistake me saying this is one of those everybody's got to do this. It's not for everybody. But if you understand the rules, it can be a very, very smart strategy. So we have a lot of clients that will create a certain kind of a trust that's called a Medicaid irrevocable trust. The word Medicaid never shows up in the document. It's just referring to the main threat most of our clients are worried about. Now, trust in general, we do programs where we'll talk a whole hour about trust. So we can't go into all the details here, but every trust needs a trustee and beneficiaries. And if we're using this as a strategy for protecting your assets against your long-term care, we can't have you be a trustee and we can't have you be a beneficiary, but we deliberately create the trust in a way where you can still keep a lot of indirect control over what's happening, meaning you can still replace who the trustee is and you can replace who the beneficiaries are. So that's why you're giving up direct control by you not being a beneficiary, but you keep indirect control by being able to make some changes to this arrangement if you needed to. So don't lose sight of the 5 years. That's important. The 5 years, essentially, if we have a trust where you are not a beneficiary, then as far as the state's concerned, this is a gift. This is just as much a gift as if you handed a check to your daughter. So in that sense, we really need this in place for 5 years before we could confidently say it's fully protected. Think of it a little like you've slathered a thick layer of clay around your assets, but it takes 5 years to harden because of the look back period. Now, why a trust at all? That sounds complicated. Can't I just give the house to the kids? Can't I just write a check to my son? You can, but it is a little risky. Why do I say it's risky? Well, of the parade of horribles, here's a few examples. What if your child is getting divorced? What if your child, the one you've named as a beneficiary on paper, what if they lose a lawsuit from a car accident? What if you have basic estrangement? I was relying on my daughter to be trustworthy, and one day she calls me up, Dad, I was thinking about it. My therapist made me think clearly you've been a jerk for 10 years. I've had it. I'm going to kick you out. Drugs, alcohol, gambling. What if your child predeceases you? There's all sorts of possibilities. I can share with you a real life example of where that met with the ability to make changes really came in handy. I met with a client a few years ago. They put their home in this type of a trust about 6 years before. So in other words, it's earlier than the 5 years. They were not worried about their house being vulnerable from Medicaid. That clay metaphorically had hardened. What they were far more worried about was the fact that their daughter, who was named as trustee and named as a beneficiary, daughter was getting divorced and it was looking ugly. And their biggest concern was, what if our soon-to-be ex-son-in-law's divorce lawyer looks at this trust arrangement and says, I think a portion of the equity over here should be part of our settlement negotiation. So they used their ability to make changes that they held on to by removing her as a trustee and a beneficiary for the time being. They're not going to leave it that way permanently, but they're doing it to sort of bring her marital problems out of their own home and until the dust is settled. So that's an example how if they had simply given the assets, given the house to the daughter, it could not happen, because at that point the house would have become the daughter's asset free and clear. Hope that makes sense. So here again is why this is smart to do. Now, this is an important point. Some people are dazzled and amazed by the word trust. They think if you hear the word trust, it means all our problems are solved. Well, I always describe it with clients this way. A trust is nothing more and nothing less than a tool in the toolbox. Like every tool in the toolbox, some tools are good to fix certain problems, certain tasks, and other tools are lousy at other jobs, tasks. So a lot of people have what's called a revocable living trust, a revocable living trust. And that's a very good tool in the toolbox. It does a lot of things for us. But what it does not do, absolutely does not do, it provides no asset protection against our own possible long-term care problems. It is simply a strategy that was designed to fix other problems other than long-term care situations. So that's why it's very important. If somebody calls me up, calls our front desk and says, hey, Dad has a trust, that means he doesn't need to worry about that, right? I say, until I've seen the trust, seen what it says, read it, how it's written, I can't possibly answer the question whether that trust fixed this problem as we're worried about long-term care. So here, just really quickly in a nutshell, revocable living trust can be very good for probate avoidance. They can be a very good way to avoid probate if you own property in other states. It can be a good tool for privacy. If we don't want a public probate process so nosy neighbors can go and see what I owned, we can put it in trust and kind of hide it a little bit. If the couple has a lot of money, it can be a good way to minimize estate taxes. But over on the other hand side is where we're again emphasizing that irrevocable trust is very smart. One last point here is if you get to the point of needing Medicaid, just beware, there are a number of for-profit Medicaid application services out there. They're not law firms. And a lot of the nursing homes have arrangements with them. And one of the things I think to make sure you understand is if they mess things up, you have much less recourse. We as law firms, we have malpractice insurance, we have a grievance committee. If we mess up something, we can be held accountable. These for-profit services are not, and I've heard horror stories. One horror story I heard is a situation where there was a healthy spouse, wife living at home, and one of these for-profit Medicaid prep services told them she has to get a mortgage. She has to get a mortgage on the home to pay for the care. And that's a blatant lie. It's either a lie or they misunderstood the rules because she was under no obligation to do that. Now, 3 minutes. It's 2:57. If you want to unmute, if anybody wants to throw in any questions here, I'm happy to try to address a couple of questions.